Now that you've mastered the court structure, we can move on to court procedures. This video will introduce you to learning objectives 5 through 10. Much of Objective 5 was covered in the preceding section, so our focus here will be to describe the purposes of an initial appearance, define bail and outline the various forms of pretrial release, briefly define a grand jury and state its purposes, describe the purposes of the arraignment and the plea options of defendants, describe the interests served and not served by plea bargaining. Most cases are resolved before trial, usually in the pre-trial stages. This video provides a summary of these steps. Professor Reese also advises reviewing your text thoroughly. Booking involves recording suspects' names, charges, and potentially their fingerprints or photographs in official records. There are 3 main types of charging documents: a complaint, an information, and a grand jury indictment. A complaint is a document alleging that a person named or described has committed an offense. An information, used in states without grand juries or to circumvent the grand jury, specifies the formal charge or charges, the statutes allegedly violated, and supporting evidence. A grand jury indictment is a written accusation issued by a grand jury asserting that one or more individuals have committed a crime. An arrest warrant is an official order directing law enforcement to arrest a specific individual with charges detailed on the warrant. Once charges are filed, suspects become defendants and appear before a lower court judge for an initial appearance. At this stage, they receive formal notice of the charges and are informed of their constitutional rights. For misdemeanors or ordinance violations, a summary trial may be conducted during the initial appearance. A bail bond or bail is typically a monetary deposit made with the court to ensure the suspect's or defendant's appearance at future stages of the criminal justice process. It permits them to remain at liberty while awaiting further proceedings. Bail is not considered a fine or penalty, but serves as an incentive to appear as required. The primary factors influencing a judge's decision regarding bail amount or eligibility include the likelihood of appearance and the seriousness of the alleged offense. Holding suspects or defendants in jail without giving them an opportunity to post bail because of the threat they pose to society is called preventive detention. Preventive detention is used most often in cases involving violent crimes, drug crimes, and immigration offenses. If a suspect or defendant fails to appear as ordered, the court forfeits the bail, and a bench warrant is issued for arrest. Estimates suggest that approximately 10,000 criminal defendants fail to appear annually, resulting in significant costs to local governments. The Eighth Amendment does not guarantee bail for all suspects or defendants, but stipulates that when bail is granted, it must not be excessive. Criteria for determining excessiveness include the nature of the offense, the strength of the evidence, the individual's character, and ability to provide bail. The bail system has received criticism regarding its impact on economically disadvantaged individuals. For minor offenses and where suspects or defendants have community ties, they are often released on their own recognizance. Release on own recognizance, ROR, involves a written promise to appear in court. Conditional release is another non-financial release method, imposing certain restrictions, while unsecured bond allows release without financial payment unless the defendant fails to appear. Preliminary hearings are used in about half of all U.S. states, including Kentucky. They apply only to felony cases. Their main purpose is for a judge to determine whether there is probable cause to support the charges filed by the prosecutor. Defendants have the right to waive this hearing. A grand jury typically consists of 12 to 23 citizens who meet in closed sessions for a set period, usually around 3 months. The number is 12 in Kentucky. They review charges, often those emerging from preliminary hearings, or perform other investigatory duties. The primary role of the grand jury is to determine whether probable cause exists to formally charge the accused. Before presenting a case to the grand jury, the prosecutor prepares an indictment outlining the charges. Witnesses may be compelled to testify through a subpoena, a legal order, issued by a court official. Those who refuse to testify can be held in contempt of court and jailed until they comply. An arraignment is a formal court proceeding where the charges are read and the defendant enters a plea. The most common pleas are guilty and not guilty, though some jurisdictions allow a plea of nolo contendere, no contest. Defendants may also plead not guilty by reason of insanity or choose to remain silent, which is treated as a not guilty plea. During arraignment, the judge may also assess the defendant's mental competency to stand trial. In some cases, defense attorneys may file motions to dismiss the case at this stage. Roughly 95% of felony convictions result from guilty pleas rather than trials. There are three main forms of plea bargaining. The defendant pleads guilty to a lesser offense. The prosecutor recommends a lighter sentence in exchange for a guilty plea. The defendant pleads guilty to one charge in return for the dismissal of other potential charges. Plea bargaining is not constitutionally or statutorily required, and prosecutors are not obligated to offer deals. However, it is widely used because it serves the interests of many parties involved: prosecutors, judges, defense attorneys, and most defendants.